Now we move to Washington to discuss the Supreme Court's new term. They just heard oral argument in cases that could impact affirmative action, the way that colleges and universities consider students for admission across this country. What are these cases about? What are the implications? What are the arguments on both sides? We want to dive into that discussion today with our special guest, Professor Francis Boyle. Many of you may know him. He is professor of law at the University of Illinois, and he is the author of many books, including Tackling America's Toughest Questions. We're very happy to have him with us here today. Professor Boyle, good afternoon. How are you?
Thank you. Assalamu alaikum. Thank you for having me on.
Wa alaikum assalam. Thank you so much for joining us. So, Professor Boyle, first, tell us about these two cases before the Supreme Court that are being argued, the Harvard case and the other case, both related to affirmative action.
Well, we have to understand that this Harvard case, I'm a triple Harvard alum, so I've been following it, was maliciously set up by individuals and groups in this country who want to terminate affirmative action for good. So they started it right at the beginning there at Harvard, moved up through the Court of Appeals, and now it's at the Supreme Court. UNC was added on. Harvard's a private school subject to a different regime than UNC, which is a state school. So what they want to do here is completely strike down affirmative action in higher education and by implication anywhere else in the United States of America. I'm afraid that's what's going to happen here. It's been teed up deliberately to this Supreme Court, where you have 6 members of the Federalist Society, which is diehard, bigoted, racist, elitist, homophobic, totalitarian, sexist, and anti-labor, anti-union. So I suspect what we're going to see is a 6-3 decision against all affirmative action in any higher education, private or public, and also pretty much striking it down anywhere else in the country. That is what we are facing. I'm afraid this decision is predicted to come out by July 1. So I guess we all have to be bracing ourselves for it.
So, Professor Boyle, tell us this. What is the current state of affirmative action in the country? Because the Supreme Court has already whittled away at this to some extent, but kind of kept it alive on life support. Right now, what is allowed and what is this argument about? Like, what is the last remaining aspect of affirmative action that universities, colleges can pursue? And what are the arguments for and against it legally that both sides are making?
Well, you have to understand affirmative action was the brainchild of my teacher, mentor, and friend, Professor Clyde Ferguson at Harvard Law School, who was the first full professor, tenured African American on that faculty, and a graduate of Harvard Law School, a teaching fellow at Harvard Law School. And Clyde originally intended affirmative action as being rectificatory justice, as defined by Aristotle in Book 5 of the Nicomachean Ethics. That is remedial justice for the fact that Africans were the only people brought here to the United States as slaves and kept in slavery for centuries. And even after the Civil War, you had de jure apartheid against African Americans until the U.S. Civil Rights Act of 1964. Clyde was working for the Department of Justice at that time, had a role to play in that. The head of that at the time was my friend Ramsey Clark. They drafted the U.S. Civil Rights Act of 1964. Then came the Voting Rights Act. I know Ramsey was involved in that, which, by the way, the current Supreme Court under Justice Roberts gutted Section 5, and they're probably going to get rid of the rest of it soon. And then came the Fair Housing Act of 1968. only as recently as 1968 could it be said that African Americans no longer live in a de jure apartheid state, but clearly they live in a de facto apartheid state. Just read the Apartheid Convention. Now, what happened was that instead of the powers that be and the Supreme Court arguing this as a matter of rectificatory justice for African Americans, in the Bakke decision in 1978, the Supreme Court, in an opinion by Justice Powell, who's a diehard racist from the neoconservative South, switched the entire rationale to so-called diversity. And that argument is racist in itself because the argument is, oh, well, it's good for the white students to have black students around. It's beneficial to the white students. Well, how are you going to win an argument like that? And so that was what they were arguing on Monday. And it's clear that diversity is going to be struck down for sure.
Gotcha. So tell us about this. What do you think how would the legal argument be made in the alternative? So you just noted that Justice Powell kind of switched the argument to this diversity framework, which seems likely to fall. Is there a different legal argument that could have found more success even with these kind of justices, or was it just doomed no matter what the explanation for affirmative action was?
Well, certainly, in my opinion, it should have stayed the legal argument on the legal and moral grounds as articulated by Professor Ferguson. Restorative justice, remedial justice for African Americans. That was a defensible position. Moving it over to diversity just made it wishy-washy, that it's affirmative action is good because it's good for white students to have Black students around. But that's what happened in Bakke. Powell wrote it. He was a bigot and a racist from the South, a neoconservative South. So, of course, it wasn't going to last very long if that was how you were justifying it, which has been the case since Bakke.
So if the Supreme Court rules as you expect, how do you think schools would respond? I think it was Justice Gorsuch who made a remark that, look, if Harvard wants to consider race in its application process, it can just stop accepting federal funding, which is not necessarily a practical suggestion. But how do you think schools are going to react if the ruling does come down the way you expect, private schools versus public universities?
Well, I think Harvard will try. I've spent 7 years at Harvard and 2 years teaching undergraduates at Harvard. I think Harvard will try to keep minority students at Harvard. They'll go back and figure out some way. It might not be the same number, but unfortunately, I think bigots and racists in higher education are simply going to use this in order to gut affirmative action for minority students across the board, and the numbers will significantly decrease. But I do know my experience at Harvard. I believe they're going to try. I hope so.
Now, would it be the case, Professor, as you may have noted, that schools could, instead of just making a decision based solely on someone's race, look at their personal experiences, right? The obstacles they've overcome, perhaps because of their ethnic background? Would that be something they could still consider, not necessarily what the color of your skin is, but what life experiences you've had in determining whether or not, that can make a positive contribution to the campus that they want to consider? Would that be an avenue by which you're still potentially able to consider and bring in minority candidates who might otherwise be no different than a candidate who is white?
Yes, I think Harvard would do something like that. I'm not here speaking, for Harvard, but my experience there, I suspect they will do that. And they will also consider socioeconomic status. As you know, all these tests are heavily weighted in favor of your socioeconomic status. So there are ways that I think it can be devised to keep minority students on campus. I think Harvard will try. Other campuses, I suspect the administration will just succumb and say, fine, let's get rid of it. I hate to say that. I can't speak for everywhere else.
Of course, of course. Now, for our viewers who may not be, I mean, I'm a lawyer, you're an attorney as well, and a law professor. Can you explain the difference between these cases? For example, North Carolina dealing with a public university, Harvard, a private university. What are the different legal issues at play? The constitutional versus federal law issues. How are the justices going to be making slightly different, or are there different conclusions at all? Because of the different types of schools. And also, I've noted Justice Jackson recused herself from the Harvard case because of her connection there, but she's still participating in the UNC case. So just can you explain what's the difference practically between the public university situation and the private university situation?
Right. The Equal Protection Clause of the U.S. Constitution applies to the public universities. It does not apply to a private university such as Harvard, but there is a federal statute. So I suspect the UNC case will give the Supreme Court, this Federalist Society Supreme Court, this racist Supreme Court, very broad leeway to strike down affirmative action across the board, not just in higher education, but in any other type of setting. I'm afraid so.
Yeah, so it's fascinating, Professor. So in one case, you're looking at the Constitution and what it says, and that applies to UNC, a public university. And then in the Harvard case, you're looking at what federal law says and how that applies to a private university that receives federal funding. So question for you, one last question before we let you go. Is it possible that, for example, Congress could amend federal law to clarify what it means when it says a university cannot discriminate? That doesn't necessarily mean that a university cannot consider someone's ethnic background and the diversity of their campus and their experiences, their unique experiences and perspectives in considering their admission to school. Given the dynamics in Congress, not likely, but could that possibly be a way in the long term to address the federal law issue, not the constitutional issue?
Well, that's the problem with the UNC case. You see, it involves the Equal Protection Clause. And when the Supreme Court makes a ruling on the Equal Protection Clause, that will be constitutional law, depending on what they say. And if it is constitutional law, then there's not much Congress can do about it. I regret to say that.
Right.
I'm sure Congress.
Federal law. No, I follow you there. But on the other case, the private university case, which is implicating federal law regarding federal funding, is it possible Congress could, for example, clarify what they mean, what the law says in terms of funding and anti-discrimination? Possible?
Yes, they could do that. Sure. Gotcha. They could try, and they'll be taken back to the Supreme Court. We'd have to see what happens. Right.
Yeah. Well, I suspect that if the rulings come down the way that you expect, people are going to be getting very creative and thinking outside the box in different ways come next summer. But we shall see. Thank you, Professor Boyle, for coming to share your unique perspectives with us, and we look forward to continuing discussion of these important issues in the Supreme Court's upcoming cases. Thank you so much.
Thank you.